Good morning, everyone, and welcome to today's Beasley Allen webinar, Gearing Up to Help Camp Lejeune Water Contamination Victims. My name is David Byrne, and it's my pleasure to introduce our panel of speakers for this very important and very timely litigation topic. Today, we're going to hear from Beasley Allen attorneys Rhon Jones, Matt Pettit, Julia Merritt, and Trisha Green. And we're delighted to have a special guest with us today, attorney and retired Marine Corps Colonel Andy Harp from the law offices of J.A. Harp in Columbus, Georgia. Together, our speaker panel will provide an overview of the recently signed Camp Lejeune Justice Act. They'll discuss the Act's benefits and eligibility requirements, and they'll address the things that you should look for when screening cases. Before I turn the program over to our speakers, and while we're waiting on the last of our registrants to join us, let's go over a few housekeeping notes. Today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order to receive full credit for attending, you got to stay on the line for the duration of the program. A copy of your evaluation form and a link to today's presentation were included in the Zoom confirmation email you should have received when you registered. But don't worry, following today's program, you're going to receive another email with a copy of the evaluation form and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. That's webinars@beasleyallen.com. Folks, this webinar is being recorded. And for those participating by phone, just for those participating by phone, we need for you to email us your name, phone number, and state bar ID number. You can send that also to webinars@beasleyallen.com. You got to do that in order to receive full CLE credit. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding more webinars throughout the year. For anyone needing ethics credit, we're offering an ethics webinar in November. I also want to encourage each of you, go ahead and register for our September webinar series, where Ron and his team will provide an additional update on this rapidly evolving Camp Lejeune water contamination issue. That follow-up program is scheduled for Wednesday, September 21st at 11 a.m. Central, noon Eastern. Finally, if you have questions during today's webinar, I want to encourage you to use the question and answer feature located at the bottom of your screen. We're going to set aside plenty of time at the end of today's program to try and tackle all of the questions submitted by our viewers. And of course, if you'd prefer, you can send your questions privately to our panel members after the presentation is concluded. Right now, we have the email addresses up for all of our program speakers. Jot down those email addresses again. Feel free to send questions privately to them if you like. So with that, Ron, Matt, Julia, Trisha, and Andy, the podium is yours. Let's get started.
Thank you, David. My name is Andy Harp. I had the pleasure for the last 2 decades of working with the Beasley Allen firm, and my experiences of those 2 decades have been highly professional, highly efficient, and done a great job for my clients. The other aspect of it is that when talking with Ron, I mentioned the fact that this is an unusual clientele. Marines, they're very special. Years ago, I was in London, England, and I passed a little shop that had ties and buttons and cufflinks. And I went in and I said, what do you have here? And he said, well, we have this. And I noticed that they had some Royal Marine cufflinks and buttons. I said, well, I'd like to buy some of those. And the guy said, I'm sorry, sir, you cannot buy those. We apologize, but those are for Marines. And I said, well, would it help that I am a United States Marine? And he said, of course, they're yours. So it's a special crowd of clients that have been victimized by this circumstance. In a very short period of time, I have been tasked with summarizing the Marine Corps and its relationship, particularly to Camp Lejeune. The Marine Corps is one of the smaller services that we have. The Army may be 600,000-700,000. The Marine Corps, in comparison, has an active duty force of about 186,000. It's been said that of that 186,000 Marines, about a third are in administrative jobs, such as at the Pentagon or wherever, and about a third are in training, and about a third are in what we call the fleet. The fleet is composed on active duty of 3 divisions. 1st Marine Division, which is at Camp Pendleton, California. 3rd Marine Division, which is in Okinawa, and the 2nd Marine Division, which is at Camp Lejeune, and has been for decades. A division is about 16,000 troops, and of that subdivision, there are a unit because we are what's called the Marine Air Ground Combat Force. We combine everything. What makes us different is that we have air, we have ground combat, we have logistics, we have special operations, all are in a Marine task force. Also at Camp Lejeune is the 2nd MEF, which is the 2nd Marine Expeditionary Force, which is another component that serves the Atlantic and the Mediterranean and the Persian Gulf areas. Why do I mention all that? Because it's the path of the Marine that brings us to Camp Lejeune that you need to be aware of. A typical Marine goes into boot camp, and probably everybody here knows of Parris Island. If you enter the Marine Corps east of the Mississippi, you go to Parris Island. If you enter west of the Mississippi, you go to San Diego. If you're an officer, you go to Quantico. At Parris Island and San Diego and Quantico, you learn the basics of the Marine Corps, which are rifle marksmanship, discipline, all those things. But as after that, we are different in that every other person that has a training that's called an MOS, a military occupational specialty, or MOS. That's important as it relates to Camp Lejeune because Marines go from Parris Island to an infantry training command at Camp Lejeune, where they're there for more than 30 days. And then they may also go to Camp Lejeune for schooling, which is usually 12, 14, 16 weeks. The supply school is at Camp Lejeune. A lot of these schools are at Camp Johnson, which is the old, one of the older parts of the base. And Montford Point was the original area of that. So you have at Camp Lejeune, you have schools, military schools, you have active military force, and you also have at New River, you have aviation components. Now, the aviation component at New River is about 2,000 to 2,100 Marines that go through there. Now, each of these Marines may have a spouse. They may have children. They may be billeted at Camp Lejeune. And during this period of time, you're talking about the Vietnam decade. So during those times, you might have a Marine that was assigned to the 2nd Marine Division that was sent to Vietnam for 12 or 13 months, and his spouse and his children remained at this toxic situation, this base. So you have virtually most of the Marines that pass through there are more than 30 days. Their spouses and their children are more than 30 days. So you've got that aspect of it. When you talk to a Marine, the commonality of it will be, what unit did you serve with? Well, I served with 2nd MARDIV, as we call it, 2nd Marine Division, or I served with a MEF, or I served with the wing. That's what we call aviation, like New River. That will be one of the things that commonality will say. A lot of these folks too, the spouses are very intertwined in the Marine Corps experience. If one is married to a spouse during any period of active duty, or even during retirement, they are likely to attend the Marine Corps ball. It's just an aspect of it. The children probably very, very familiar with the Marine Corps ethos. So it's integrated across both the spouse and the children, and maybe even the grandchildren. A lot of times you'll see the grandchildren go to Parris Island, and their grandfather will attend the ceremony. So, I mean, it's really integrated. Camp Lejeune, like I say, is a command that has an amphibious aspect to it, where I personally did an amphibious landing at Camp Lejeune. But it has all these different elements that you're there for, like I say, for quite long periods of time. Literally, a third of the Marine Corps goes through Camp Lejeune. And the thing about the military is it's so transitory that you'll have somebody that will go to Camp Lejeune, and he may be there for 2 years on what we call PCS orders, permanent change of station orders. He may go off and serve in Washington, D.C. He may go off and serve somewhere else, and they may have orders where they send him back to Camp Lejeune. Now, like I say, you're talking about this time period of August 1st, 53 until 1987. You're talking through the heart of the Vietnam era. So there, the Marines would go to combat tour, and they would leave their family behind, and they'd be in combat in Vietnam for generally 13 months. So there's commonality is of the path that Marines take, the commonality of what their MOS is, and what the rank is also a factor, something that you would have a conversation with Marine about. The other thing about it is what these Marines participate in post-service. And of course, we know the American Legion is one. The Veterans of Foreign Wars is one. If you served in a combat war situation, is one. The Marine Corps League is a very powerful component of it. There are a lot of Marines that participate in the Marine Corps League, and the Marine Corps Reserve Association, which used to be the Marine Corps Reserve Officer Association. Those are some of them. There are other sub-entities that are involved, like if you were with an aviation unit, they may have an organization. If you're with an infantry unit, they have an organization. So ultimately, what we're talking about here is a lot of people flowing into Camp Lejeune and flowing out of Camp Lejeune, virtually all of them there for more than 30 days, and exposed in these different areas like Terrace and these other places to this horrible and toxic environment. If you have any questions about this, please do not hesitate. I'll be happy to help any way I can. Thank you very much. Thank you, Rhon.
Matt, if you want to go on to the next slide, I can get going. Hi, my name is Julia Merritt. I'm an attorney at Beasley Allen in the Toxic Torts section. And Andy, thank you so much for shedding some light on the Marine Corps. And I encourage all of the attorneys out there handling claims to learn more about these clients. They're special clients. They have their own culture. There is a lot of history, and we need to really respect them, understand their lingo. So Andy, thanks for introducing a little bit of that to us. So the Camp Lejeune litigation, I'm going to give a brief. There's so much to talk about, but we only have a limited time. I'm going to talk a little bit about the contamination history. Camp Lejeune was opened in 1942. This litigation is for people who were exposed between August 1st, 1953 and December 31st, 1987. During that time, there was significant contamination of the water supply at Camp Lejeune. And there are different kinds of chemicals. They are VOCs, volatile organic compounds. And it's absolutely outrageous, the levels of contamination that we're talking about here. The government knew about this as early as 1982. Matt, if you could go to the next slide, please. The document that is the playbook for this Camp Lejeune litigation is entitled The Assessment of the Evidence for the Drinking Water Contaminants at Camp Lejeune and Specific Cancers and Other Diseases. It was published on January 13th, 2017, and it was created by ATSDR, and that stands for the Agency for Toxic Substances and Disease Registry. I encourage all of you to read this document from the beginning to the end. It's 152 pages. It is extraordinarily detailed about the contamination history at Camp Lejeune and which diseases are affected at Camp Lejeune. It has a lot of different elements, and it's also an epi report, an epidemiology report. So use this as your guide to file claims and eventually draft your complaint. If you could go to the next slide. This is just the very beginning of this document, and you can access it online. You can always email me, and I'm happy to send it to you. The contaminants at issue, and you can see it in the highlighted section, are TCE, PCE, benzene, DCE, and vinyl chloride. Now, these are some of the most toxic chemicals on the planet. And I'd like to tell you about the levels of contamination. So beginning in, let's see here, 1982, samples of the water at Had Not Point treatment plant were taken by the government. TCE was found at 1,400 parts per billion, and the allowable level is 5 parts per billion. So we're at over 1,000, over 1,395% per billion more than what is allowed here. It's outrageous, and it's caused, unlimited deaths and injuries, and it's just unbelievable. PCE is the next one, 100 points per billion. Also, only 5 points per billion ppbs are allowed. Vinyl chloride was detected. Benzene was detected. We had diesel fuel leaks. There was a dry cleaning plant that had a toxic spill. And so this report is very important for you to be able to understand the location of the toxic spill and leaching, what toxin was at issue, and then what disease is connected to that toxin. So just understanding that your client was at Camp Lejeune in, say, 1965 and has breast cancer or liver cancer. You need to dig deeper. You need to figure out where were they residing or working at Camp Lejeune, what chemical were they exposed to, and then go to this ATSDR report and find out if there is the right amount of causation, equipoise or higher, or is there actual causation, or is it equipoise and lower? And of course, we're not going to solely rely on this ATSDR report. There are so many other diseases at issue here that are not in the ATSDR, cervical cancer, all different kinds of cancers, miscarriages, stillborns, wrongful death. So this is just the start of what we need to do as attorneys to dig into this litigation and figure out what other illnesses we're going to be able to help our clients recover for. Let's see who's next. Trisha? I'm sorry, Matt, you're going to be talking about the Camp Lejeune Justice Act now.
Yeah, thanks, Julia. It really can't be stated enough. The Marines and their stories, the servicemen, it's really going to be the foundation of this litigation. Getting to know your clients, getting to know their stories, it's going to provide a lot of motivation for us as attorneys. And also, it's just going to be really crucial in this upcoming litigation. So what I'm going to be talking about today is just some of the highlights of the Camp Lejeune Justice Act, because it is a unique statute that has been created for this to give these veterans the ability to recover that has been so far denied to them. So Camp Lejeune Justice Act is part of a larger act. It's part of the Honoring Our Pact Act. The PACT Act was signed by President Biden August 10th, 2022, and this is a really important date to keep in mind because the act itself places limitations on when these cases can be filed. And so the act outlines that you have 2 years from the date of the signage of the act to file these claims. If you would like the full text of the bill or of the act, there's a link right there in the webinar, and the Camp Lejeune specific portion starts at section 804. So there are a lot of unique aspects of this, and it makes it a little bit different than most civil litigation that's going on right now. For starters, like I mentioned, there is a limited finite filing period. It's 2 years from the date of signage. The next interesting thing is that there is exclusive jurisdiction in the Eastern District of North Carolina. This is written into the act itself. This is not a multi-district litigation. It's not a class action. The JPML consolidation rules really aren't at play here. It's just been localized there for the purpose of this act. Another interesting part is that the burden of proof, the act itself has a line in there that states it's the burden of proof is a casual relationship that is at least as likely as not. And so generally with most civil litigation, you're looking at preponderance of the evidence and you're looking at greater than 50%. For this act, it's more, the burden of proof is that it is at least 50%. So you can see that that difference is written into this bill for the purpose of allowing these individuals to try to get recovery. Another interesting part is that the act itself has its own unique statute of limitations and statute of repose. North Carolina's statute of limitations and statute of repose aren't at play here. And that was one hindrance that prevented a lot of these claims from being litigated prior to the passage of this act. So the act has its own unique one, and that's that 2 years I was talking about. So this also extends to wrongful death cases. A lot of times in previous litigations, if you have a decedent who passed away decades ago, well, you wouldn't be able to bring a claim. But under this act, even those wrongful death cases will be able to be brought for on behalf of those injured or those decedents to recover for them. There is a prerequisite to filing a civil action in this Camp Lejeune Justice Act, and that is that you have to file an administrative claim before you can then file a civil litigation. So we'll get into the administrative claim and that process a little bit more in depth with Rhon, but just generally speaking, it's very important to know that the administrative claim that is going to be filed is not being filed under the Federal Tort Claims Act. It is unique and separate, and you'll need to do your due diligence to make sure that you are submitting the administrative claims to the proper location and to the proper authority, because the last thing that you want to happen is for your case to accidentally get swept into the Federal Tort Claims Act. So, and what's also unique about this administrative claims process is that this really serves merely as a notice provision to the government. It's in the bill to provide notice and to let them know that there is an intention to move forward with a civil litigation. The act itself also limits the government's defenses. Like I've mentioned earlier, it imposes a new statute of limitation, new statute of repose, and it also removes immunity. But another defense that it will remove is the Ferris Doctrine. And the Ferris Doctrine is essentially a defense that prevents members of the armed forces who are injured while on active duty from successfully suing the federal government under the Federal Tort Claims Act. So with these defenses removed, we're very hopeful that this litigation is going to move forward pretty quickly and that the government will have to rely on probably some more unique defenses that most likely won't hold as much weight. Another interesting aspect is the language about offsets, offsets of specifically VA benefits, and then of course Medicare, Medicaid, and all those related ones. We're going to go into details about the offsets a little bit later, but the most important thing and the thing that we get almost daily from all these clients is what is the impact that this claim is going to have on my VA benefits. And it's not going to impact their monthly benefits. At most, it's going to impact the potential award or settlement that they are offered under the Camp Lejeune Justice Act. The funding structure for the act itself is also pretty interesting because the money is allocated from the judgment fund, and the judgment fund will allow, it doesn't place a ceiling on the amount that is allotted to this bill, and it makes it where there is not going to have to be repeat votes on funding this from Congress or anything like that. So that's a very unique aspect of it. And also, the damages that are available for this are strictly limited to compensatory damages. You will not be able to file for punitive damages. And so that is why it's so important to know your client, know their story, because that story is going to help you maximize their claim and help them get the relief that they have so far been denied. And so, and the one last part is, like I've hit on before, the Camp Lejeune Act is completely and wholly separate from the Federal Torts Claim Act. It borrows the notice provision to let them know what's going on, but it is completely separate. So you're going to want to make sure that you are following the correct procedure to make sure that your administrative claim ends up in the right position, so you can then start focusing on your civil litigation claim. And I think that is it for me. So I'm going to hand it over to Trisha.
Thank you, Matt. I am the intake attorney for the toxic torts section over here at Beasley Allen. So I just wanted to kind of share a little bit about intaking these Camp Lejeune cases and maybe give a little more insight into screening them. In my mind, it's kind of the criteria is a two-pronged process. The first one's not very flexible. It's that they had to have had that exposure for at least 30 days at Camp Lejeune to the water between August 1st, 1953 to December 31st, 1987. The law has laid out these exact dates, so that's kind of an easy one to either yes or no on. The second prong is a little bit more complicated. It's that they have some sort of injury caused by the contaminated water at Camp Lejeune. One of the silver linings that Julia kind of discussed with those reports from the law being so far removed from that exposure long ago is that we've had time to do those studies and look into the contamination and the types of injuries that occurred from that exposure. So in that time, the VA has acknowledged that there are 17 injuries that were caused by the contamination. And so with those, we have presumptive causation, and we list those in what we call tier 1. Everything else kind of falls into tier 2. And it's not that they're not good cases. They're still great. You should still fight for these clients. But just keep in mind when you intake them, there's going to be a different burden on you for causation. And I've kind of listed out here some of the more common ones, but it's not an exhaustive list. It's just kind of to give you an idea that some of the things that aren't on that presumptive tier 1 list are still pretty serious injuries. And you're going to come across other ones as well, and you should definitely look into them. But these are just kind of to give you an idea that there are still some pretty common ones, and they're still pretty bad. I also wanted to point out that when you look at these lists, and it's kind of been touched on already, that there's a lot of injuries relating to children and childbirth, a lot of miscarriages, birth defects, stillborn babies, babies that only lived a couple days. These cases are absolutely heartbreaking. Babies and children dying was so common at Camp Lejeune that there is more than one cemetery there referred to as baby heaven, just full of these children. So keep in mind when you're intaking these cases that some of these people really are going to tell you about one of the worst things that happened in their life. You really have to give some extra thought and care in handling these phone calls when you talk to people about how they were just living on a military base and the government poisoned them and they lost their children. Sometimes people had multiple miscarriages. It's hard emotionally and mentally for people to go through it. So I would encourage you to take extra time with these clients. Every time I talk to them, they generally don't ask me what their case is worth. They don't talk about money. They just want the government to know that what happened to them wasn't okay, and that maybe we can raise some awareness and make sure that this doesn't happen again. And that's just such a good reminder that what we're doing is important and good work, and we really get to help these people. But to be able to help these people, we have to be prepared for the actual litigation. Matt, could you change my slide, please? I just kind of wanted to go over some of the things to be aware of when you're intaking these cases. You may have also noticed when you were looking at that list of injuries that there's a lot of injuries that have also popped up in other class actions or MDLs. like Roundup with the non-Hodgkin's lymphoma. It's important to ask clients when you're screening them if they participated in any of those cases as well. If you recently argued to the court that Roundup caused your client's non-Hodgkin's lymphoma, and now you want to file a case that the Camp Lejeune did it as well, you have causation issues and probably some ethical implications as well. I don't think that participating in those other cases necessarily bars a client from participating, especially if there's a second injury. But it's definitely something you should know about, you should be aware of, you should be prepared for, you should be researching how these things are connected or how they're not, if you really want to properly handle your client's cases. And as mentioned, these cases are kind of in a two-step process. The first step is that administrative claim form. And you don't necessarily need the exact same information for your admin form that you do for your actual civil suit. But so think about that when you're collecting information that you may need something else later, and what you put on your admin form might bind you in your claim in the civil court. So keep that in mind when you're putting down any dollar amounts on your admin form claim. And also that if you don't fill out the form properly, it could get rejected, which is not the same as denied. So you need to be ready for both steps of the process. Denied allows you to move on to the next step, whereas rejected just means you didn't do it right and you're back at square one. And as Matt mentioned, the wrongful death cases are now back in play. So you have to keep in mind that some of these cases are going to be very old. These records haven't seen daylight for decades, which on the one hand is great. We get to get some justice for these families of people who passed a long time ago. But on the other hand, how do we get these records? Is there an estate? Who can open the estate? The who question is also important for not just the clients who are the Marines who are no longer with us. Make sure that the person that you're intaking and talking to actually has legal standing to file the case. A lot of people are just very excited that this is happening. So they know somebody who was there, they know somebody who suffered or died, and they just really want to call and get it going for their friend or family member. But keep in mind that legal standing is still required for whoever wants to open the case. This one, it comes up a little bit. There needs to be actual exposure to the water. A lot of contractors, say, for example, drove a taxi through Camp Lejeune, never got out, didn't drink the water, didn't bathe in it. You need to have some sort of actual exposure, whether that be drinking it, cooking it, bathing in it, but some sort of actually touching or imbibing the water, not just drove through base. And the last thing I wanted to just kind of give you a heads up about is the North Carolina ethics concerns. They're very strict about how out-of-state attorneys advertise in their state, and they are very known for investigating and pursuing those who break the rules. So you need to at least be associated with a North Carolina barred attorney and have their name in your ads. They also require that North Carolina barred attorneys play an active role in handling your cases as well. They have a lot of rules about when you co-counsel, when co-counsel has to be there. So please just make sure that you consult with ethics counsel if you have any question at all about how to handle the ability to only file in North Carolina, because you're not going to be able to get justice for anyone if you get disbarred for practicing without a license. So please feel free to reach out to me if you have any questions about intake, screening, honestly, anything, because I love to chat. Up next, Ron's going to give you more info about the first step to holding the government accountable, which is filing that administrative claim.
Yeah, thank you, Trisha. So we have before you the claims process form. Before I go into that, I want to take a moment just to thank everyone for being on this webinar. I don't think we've ever had a webinar at Beasley Allen with this many people on it. So we're grateful that you took time to be with us today. I know that you're all very busy. David Byrne, my law partner, very, very smart individual, he reminded me this morning that he and I sat in the office I'm in today many, many years ago. And we were so frustrated by the litigation that was going on at that time in federal court. It was eventually shut down by the 11th Circuit based on various rulings, including a statute of repose. And so, you know, this day is a long time coming. This is a fantastic testament to the civil justice system. So many Marines and their families were exposed to, I've been doing toxic stuff for, you know, almost 30 years now. I can't remember a more contaminated water supply than this. So it's really, really positive to be working on this and to have this opportunity. The forms, you can kind of see what's there in front of you. I can tell you what we're going to try to do, and we hope to help, you know, many, many other law firms that are working on these. You know, we're going to start filing our claim forms next week on a rolling basis. We believe that's the better way to do it, to get this process started. As you can see on the slide, online submission is preferred. You know, no supporting documents are required. We're going to take the approach that less is more, and we're going to have kind of our set minimum of the things we want, which are compliant with the form, but we're going to get those rolling and be doing those on a continuing rolling basis. A couple other points I would make. You know, if you have looked at just the scope of this litigation, there are a lot of people saying a lot of things, and of course, you know, we don't know exactly how it's going to go, but the CBO, you know, has done some estimating on the size of this. You know, all of their estimates are in the multiple billions for payout. You know, I think there was maybe a 9-10 year period that shows at least 6.7 billion to be paid out. And again, these are estimates by the CBO, so you know, take that with a bit of a grain of salt when you're dealing with the federal government. But nevertheless, the point is clear. You know, this is a very, very large project. So a couple more points. You know, really wanted Andy to be a part of this process today, because we, as lawyers, we all need to empathize with our clients. That's part of what makes good lawyers and successful lawyers, that ability to advocate on behalf of their client. These Marines and their families, this is a very special client group. You know, through absolutely no fault of their own, they were just, you know, exposed in just the worst ways to these toxins in their water. And so this is all our cases are white hat, but this is an extremely white hat kind of case. Last comment I would make before we probably move on to Q&A or whatever comes next is, you know, I've heard a lot of people, maybe they don't directly say it, but they imply that, you know, this will be easy. You flip a form over, money just starts pouring in, and you and your client are happy and ride off into the sunset. You know, we touched on the tier 1, the presumed illnesses versus those that are tier 2. But, you know, I've never been a part of anything that is sizable that's been easy, right? And you probably haven't either. So I would strongly encourage everyone to be thinking in terms of, you know, a fairly difficult and lengthy battle here. I'd love to be wrong. Nothing would make me happier than to be able to process, you know, quick compensation for very deserving clients. But as we all know, that's just generally not the way the world works. It's not the way large corporations work. It's not going to be the way I predict the federal government will work in this situation. So, you know, we need to work together. We need to be resolute. We need to, you know, be ready for a lot of difficult work, from the claims process to the expected denial, to the litigation aspect of this. So I can assure you that at Beasley Allen, we're very much prepared to devote as many resources or as much as is needed to get this done properly. It's always been the way we've done things, and I hope it's always the way that we will do things. So, I think there's going to be a lot of work required to get where we want to get to properly serve our clients. So, I do take a little issue with people that just think it's just going to be easy. I don't take that approach. And so, if you have any questions, I'm sure we'll have a Q&A time here. David will pop back in if he's next, or if I'm supposed to do something else, they'll tell me. But whether we answer your question today during the webinar because the time is limited or not, just please rest assured, if you submit the question, we will get back to you hopefully by the close of business today, electronically with an answer to your question. My cell phone is well known. My wife tells me to quit giving it out, but I don't care. You want to call me, call me. You want to text me. Every lawyer we have here is willing to discuss whatever aspect of this case with you during the day, at night, weekends, whatever. So we're happy to be presenting this. We're happy to be a part of this process. I think this is just an incredibly important piece of litigation that we're all going to be so proud to be a part of. So that's it from my end.
I think we have just enough time to fit in a brief overview of that offset that I mentioned before we move on to Q&A. Once again, the biggest question that we're getting is from these veterans about what's going to happen to my benefits. Are they going to be impacted? Am I going to get it reduced? I don't want to file a case if that's going to be the issue. So just so you can reassure these clients, your VA benefits, they won't be impacted. They should not be raised or lowered just because you're filing a separate Camp Lejeune Act litigation case. And really the main time that it comes into play, it's going to almost operate like just standard subrogation for Medicare or Medicaid. If you're getting VA benefits for the same injury that you are claiming for your Camp Lejeune, if or when a settlement is offered, the payment from the VA that has paid for this injury will just be offset from the total settlement or award amount. Now, if you are getting VA benefits for, let's say, cardiac issues, and your Camp Lejeune Act is for non-Hodgkin's lymphoma, then you won't have to worry about offsets at all, because it is two unique and separate injuries, and presumably the VA has not been paying you any kind of coverage for your non-Hodgkin's lymphoma. And so that was just a really quick overview, but that's a lot of the questions that we're getting. It's also, this is not a class action, it's not an MDL, and the most important thing is this is not part of the federal torts claim process. And so with that, I think we can turn it back over to our moderator, and we can try to answer some of y'all's Q&As.
All right, everyone. Okay, everyone, on behalf of all of our viewers, I want to thank Rhon, Julia, Trisha, Matt, and Andy for giving a thorough and very thoughtful presentation today. We've received a number of questions from our viewers, and if the panel will allow me, I'd like to present those to you one at a time. Our first question today comes from Lowell. Lowell asks, in California, we're seeing ads for timeframes between 1950 and 1985. Is that wrong?
This is Julia. I can answer that. Yes, it is wrong. I think what happened there is a lot of attorneys were jumping the gun before the actual act was passed, before Biden signed it. There have been many iterations of this act. There was a 2021 Camp Lejeune Act. There's a 2022. The final exposure dates allowable are August 1, 1953 through December 31st, 1987.
All right, thanks, Trisha. Our next question is from Julia. Julia asks, what were the levels of VC, I assume that's volatile organic compounds, and benzene, and what are the allowable levels?
I'll take that one too. So VC is vinyl chloride. The allowable level is 2 ppb, and benzene, the allowable level is 5. So the issue here is we've got, from the water studies, it depends on the year and the location within Camp Lejeune. So I'm going to look at Tarawa Terrace. So between the years of 1975 and 1985, the mean ppb of vinyl chloride was 5.6. The median was 6.2. And the range went all the way up to 12.3. So that's why it's so important to learn where your client lived and during what years. So you can say, well, he was there during a time when vinyl chloride was extremely high. And that's why we can prove causation in his case if there isn't presumptive causation from the ATSDR report.
Yeah, that's absolutely true, Julia and David. That's really the levels we're seeing here, having done this kind of work for a long time. The levels here are just, this is out of this world levels. This is exponential. We're normally talking about something that's slightly above the reg or the limit. This is off the charts bad. I mean, if you don't do a lot of this work, these are crazy, incredibly high numbers. And Julia makes a good point. We're finding already, someone may not remember their exact address. I mean, they could have been there in the 60s, could have been there in the late 50s. Try to find out where they were within the base. Even if they don't know the exact address, really focus on that location because it's usually one of a few places, and the time that they were there. If you can do that, then we can start reconstructing the exposure history.
Thanks, Ron. Thanks, Julia. Our next question comes from David. David asks, how will our clients know which contaminant they were exposed to? How will our clients know which contaminant they were exposed to? Who wants to tackle that?
Yeah, David, I'll take it. I mean, you kind of want to, it's a follow-up to the answer I just gave. Again, if you start with the location, albeit, again, it's going to be one of 3 or 4 places. You don't have to have the specific address number, but get that location, get that time frame. The literature is out there largely regarding which water supply was where, which contaminants were where, at what time. So you can build the answer to that question by knowing, the where and the when. Any additional details you can get regarding things that occurred or that they can remember while they were there will certainly be helpful. But if you can start with time frame and location, you're going to have a very good head start on the specific contaminants.
That's perfect, Ron. We've gotten a lot of questions in. I'm going to keep rolling along, panel. Our next question comes in from Julia. Julia asks, what evidence do we have for including other cancers, including cervical cancer, in this litigation?
I can take that one. This is where good lawyering comes in. This is where we have to, dig in our heels and start talking to experts and epidemiologists and toxicologists. And, we are not going to exclude a client who has exposure history at Camp Lejeune and a cancer, just because it's not listed on the ATSDR. We have to dig in and figure out, as Rhon said, the contamination levels are just exponentially higher than the maximum allowable limit. So it's a great question, and that's where our work is cut out for us.
Yeah, and I would add, Julia, we don't need to get into the weeds because we have a limited amount of time here, but we are actively working on every illness that's quote non-presumptive, end quote, as to the story there and what we can do. We have done this kind of work for a while now. It is a little bit of a niche area. Not a lot of firms do this kind of work, but we do have, as David can tell you from personal experience, we have a lot of exposure background. Even when it wasn't a very popular thing to be doing, we were still doing it. So we're pretty well versed in attempting to build a case regarding exposure as it relates to a number of illnesses, and that's precisely what we're doing. So I think as time goes on, there will be more information regarding different illnesses, which will or will not be proven out as far as the exposure history.
Thanks, Rhon. Our next question comes from Natalie. Natalie asks, is it 2 years to file an administrative action or to file into the Eastern District of North Carolina?
Yeah, I can take that one. So you have to have the administrative claim filed within 2 years. Once that claim is filed, you can kind of hit pause on it and move forward with other cases. But it is important to file within that time period. And this right is provided under the statute and in the act. And if you don't file within that 2 year period, your client can miss out on recovery.
Right. And I would add, and if somebody on our team needs to correct me, they can correct me. But as I read it, you have 2 years from the date of signing, or you have 180 days from your denial of your admin claim. So if you filed your admin claim 30 days before the 2 years ran and it was denied 180 days later, I still believe you can file a suit, at that point. I think it's whichever is later. And I probably should have said this. I can't believe I didn't, but I probably should have said this with the claim form. The claim form is in effect a ceiling on your compensation request. So what you don't want to do is put some, small or limited amount on your claim form, depending on the illness or exposure history. Now, some people are putting, or I think they're going to put extremely large amounts on the claim form, like really, really, really large amounts. I don't know if I think that's necessary, but I think you certainly don't want to limit yourself, but I think we're probably going to be perhaps we're going to be thoughtful in what we put on there so we don't limit it, but we're not going to put, $1 bazillion on every claim form.
Okay, our next question comes from Ann. Ann asks, since 50% of the clients I'm signing up are deceased, how is probate being handled? Specifically, getting the personal representative appointed.
Does somebody want to try that one first? Or if not, I'll give it a shot.
I can, so there's been talk that maybe at some point the court in North Carolina will step in and do something to facilitate and expedite this process because, as you mentioned, you're signing up 50% deceased clients. It's a large number. At this point, though, we can't rely on that. So the answer is it's still kind of messy, and you have to open up the estates according to each individual state law. So it's not quick or easy, is the answer.
Yeah, and so go ahead, Julia.
I'd also like to add that in order to file in North Carolina a wrongful death claim, you also have to open an ancillary estate in North Carolina. So we're going to have to be opening 2 estates if the person did not pass away in North Carolina.
Yeah, and my answer, David, would be probably a combination of those 2 things. I do predict that within a relatively short period of time, the court will lay down some rules or process by which estates are to be handled nationwide, because obviously there'll be people from all over that are bringing these claims on behalf of a loved one who is deceased. So I do think there'll be guidance there, but Julia's also correct regarding the ancillary estate. And we are in the process of building our own, model so that we can repeat this, over and over. And again, we with all due sensitivity to the family members of people who have lost loved ones, which is incredibly tragic. But, there is going to have to be a process that we follow in this regard. We're working on our own right now. It does involve, both options with the state in which they were living at the time of their death versus the North Carolina ancillary estate. So that and whatever the court's going to do, I think will answer that question. But I don't think there is a definitive answer as of today.
Okay. Well, your answer really takes us to another related question that comes in from James. And James asked, do you have to be barred in North Carolina to process an administrative claim?
So, and others may add to my answer. I think the safest approach, I think, would be working with a North Carolina barred attorney on your cases. And then there is an application process, which is somewhat difficult, probably by design. But we're taking the approach that we are working with, local counsel, if you will, on our claims. So I think that's to me, that's the safest approach.
Our next question comes from Jacob. Jacob asks, what do you guys recommend about attaching documentation to the administrative claim form? Is that unnecessary? Or do you think a failure to present adequate materials for, say, death certificates, medical records to the Department of Navy will lead to rejection of the claim?
Yeah, and that's a very good question. Other lawyers on our team may add to my answer. We're currently taking the approach that the minimal amount that is required by the form is what we're doing. If we need to add to or supplement, should we get a question that leads us to believe someone is serious about processing or paying the claim, then so be it. But I do not, and again, this is just my opinion, I don't believe that putting a lot of stuff there on the front end is gonna make a big difference. That again, just my personal opinion. We're doing as little as possible under the form, and that's our view of things.
I'd just like to,
Yeah.
Oh, go ahead, Matt.
Yeah, I was just going to add on, if you go to the Navy's website that has the form on it, there's also an instruction document that kind of tells you how they want the form submitted. And they are explicit on that at the current moment, they do not want documentation. They might reach out to you to supplement with additional documentation, but at this moment, they're really just looking for that form and that basic information. And they're trying to not get clogged down in just a torrential downpour of paperwork.
Yeah, I agree. I agree with that, David. And again, and Matt, there's, we could all speculate about how prepared they are or how not prepared they are or whatever that is. I don't know that that's particularly useful. We're going to do what the form requires and not anymore, so that we can get this process started, because again, I anticipate many lawsuits having to be filed before we get where we're going here.
Okay. We've gotten in a number of questions. We're running short on time. Let's try to tackle a few more before we have our closing remarks. And then, of course, those of you who have submitted questions on the Q&A feature of the program, look, we're going to answer all of your questions. It may be after this program, but we're going to get all of your questions answered. But let's move to the next one before we wrap up. It comes from Elizabeth, who asks, exposure of the water is required. So how will it be determined there's actually exposure to contaminated water? Is there some sort of undoubted or undisputed source of water that if you were within, say, a quarter mile of, then you certainly were exposed to according to the Act?
Yeah, so someone will probably add to my answer, but David, and again, our time is limited and we'll be happy to go in as much detail as the questioner wants, after the webinar. But again, there are places that one would have lived or been at Lejeune, which correspond with different sources and different contaminants. There is some overlap there, but generally speaking, if you lived in a certain place at a certain time, you can draw a fairly good inference that you were exposed to contaminant X, Y, or Z. So again, I think you start the building process, and David has done this many times. He's one of the best in the business at it, frankly. He's done it many times. You start with the history of the person and where they were for what length of time. And then that's going to tell you what system they were a part of. You can get information about what did they do, what did they cook, what did they drink, how did they normally live their life. And then that's how you build your model as to the exposure history. I mean, there's more to it than that. I'm grossly oversimplifying it, but that's the basic process.
Well, fantastic. As I said, we've gotten in a number of questions. We're going to try to get to all of them once we end today's program. I did want to go over some final housekeeping notes before we conclude. For those of you who may have missed our earlier discussion, following today's program, you'll receive an email with a copy of the evaluation form, the PowerPoint slides, and a video link to the recorded presentation. You can email your completed evaluation form to webinars@beasleyallen.com. Again, for those of you who are participating by phone, it's very important that you email your name, phone number, and state bar ID number to webinars@beasleyallen.com in order to ensure you receive full CLE credit. Again, check out the events page for our upcoming webinars. Registration, it is limited, so register as quickly as you can. Our next webinar is scheduled for Wednesday, September 21st at 11 Central, noon Eastern. For September, Rhon and his team are going to provide an additional update on the Camp Lejeune water contamination issue. Thanks for joining us today, and thanks to all of you for supporting our Beasley Allen webinar series. Have a great day.